appearances.
Good afternoon, Your Honor. David Defendant here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Fellas Lane.
All right, this is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161. $3,320.17.
All right.
Your Honor,
Sir, of that amount, is there any that you believe that you owe?
I was going to ask to object what he was about to say as far as about the numbers, about saying what I owe, but you already answered the question. Ask me the question.
And
I
Mr.
can break
Fenn,
down that amount if you want me to, Your Honor.
pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989. Vanessa Place is trying to help me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying to go liable.
Okay, so let me ask you this.
Okay.
Just so that I have the background on it.
This case is a perfect example of what happens when internet mythology collides headfirst with real-world consequences. What you're about to witness isn't just a landlord-tenant dispute. It's a full-scale courtroom reality check. On one side, you got a professional judge who knows the law inside and out, who's patient, measured, and willing to listen. On the other, a defendant armed with sovereign citizen talking points, pseudo-legal buzzwords, and a belief system that has failed spectacularly in courts across the country.
As far as my estate and my...
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
Plaintiff's place.
Okay, at the 315B.
Correct.
All right, that's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, whatever.
Right hand. So swear affirm the testimony you're about to give. Okay.
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had the I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. And then there's 161 in court costs. So I just want to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah.
This is a critical early moment that a lot of viewers might overlook. But legally, it's huge. The judge isn't being sarcastic here. He's establishing the burden of proof and inviting the defendant to dispute the debt with actual facts. Courts don't assume people owe money just because a landlord says so. They rely on ledgers, records, and testimony. But what's telling is how quickly the conversation shifts away from numbers and into ideology. That's the first red flag.
So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave my principal to Peninsula Place and I've never received any consideration.
Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
To do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
Well, yeah, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
This exchange perfectly demonstrates why sovereign citizen arguments collapse under basic questioning. The judge isn't asking anything complicated. He's asking where the person physically lives. Courts deal in physical reality, addresses, occupancy, possession. When someone starts splitting themselves into legal entities, estates, consumers, and natural men, they're trying to create confusion where none exists. But notice how Judge Simpson handles it. He doesn't argue philosophy. He doesn't debate metaphysics. He pins a defendant down to one unavoidable truth. Someone is living in that unit.
I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you what I'm doing.
I know what he's referring to. Can I show you?
Yeah.
Here's what he's getting, Your Honor. We have a third-party billing company called Zigo. And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attached. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place as if that's a check.
Have this marked as plaintiff's exhibit and 2. The ledger being 1.
This context is devastating to the defense, and it's why experience matters in court. The attorney isn't speculating. He's laying out documented history that shows a clear pattern. Mr. Lane previously accepted rental assistance, benefited from waived balances, and avoided trial by leveraging the system, then turned around and denied the very obligations tied to that assistance. That contradiction matters. Courts care deeply about consistency. You can't accept benefits tied to a contract while simultaneously claiming the contract is invalid.
So those payments are supposed to come to me as credit. So
What payments?
the payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Peninsula Place.
Who's giving you credit?
You said, who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest
In what?
in this so-called contract with Peninsula Place.
Okay. But who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
No, I haven't paid in US dollars.
Or anything evidencing US dollars? Like a check, credit card, anything like that?
So this is.
No, that's a yes or no.
Can you repeat the question, Your Honor?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2000?
Here's where legal terminology gets weaponized and misused. Consideration is a basic contract concept. Each side gives something of value. Rent money in exchange for housing is about as textbook as it gets. What the defendant is attempting to argue is that because he reframes payment as credit, the exchange somehow disappears. That's not how contracts work. Shelter, utilities, and occupancy are tangible benefits. Courts don't entertain abstract reinterpretations that ignore lived reality. Judge Simpson's response shows restraint, because this argument has been laughed out courtrooms for decades.
What is that? What Mr. Fantera just gave?
Yes,
How does that access US dollars?
because, Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
They show you the balance?
Yep.
Just showed you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is
No, you know exactly what I'm asking for.
you're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relations, relationships, it's sitting here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They will take it and take the check and put it on a ledger with my credit. Because if I owe something, Your Honor, it would be in a negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lang?
So where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not.
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
Debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit payments and credits.
This is the heart of the sovereign citizen payment myth, and watching it collapse in real time is instructive. The defendant claims money hasn't existed since 1933, yet somehow expects a court to recognize a private credit system with no issuing authority, no ledger, no balance, and no access mechanism. Courts don't operate on belief. They operate on verifiable instruments: cash, checks, wire transfers, account statements. Judge Simpson keeps asking the same question because it's the only question that matters. Where's the money come from?
In the Treasury.
Which treasury?
US Treasury.
Oh, so they have to go to the US Treasury with this thing that purports to be a check. Really?
They were pulling from the Treasury. That's why they asked for my information.
Who is pulling from the Treasury?
Peninsula Place, Your Honor.
So Peninsula Place is pulling from the US Treasury.
They got the account attached to my name with my social and my information.
So they're pulling from the US Treasury because of that?
Say that again?
So because of that, they're pulling from the US Treasury?
I mean, they're charging the account. So this account has my information tied into it, which is showing that it's already prepaid. So what they're trying to do is Peninsula is trying to make me repay.
You've never paid anything. So they're not trying to make you repay. They're trying to make you pay.
Your Honor, so how did we get here if I provided my information to Peninsula Place?
We got here because you have never provided them anything
Okay.
to pay on this account in US dollars or anything evidencing US dollars. That's how we're here for 5 months. You haven't done that.
Okay. So in the contract, it says payment and then specify what type of payment. Your Honor, this is evident.
Hold on.
Okay.
In order to pay in credit, if you will, you must have something that evidences a balance on that credit. I've already asked you once. Why not? I'll ask you again. Show me something that evidences the credit.
That shows the credit, the birth certificate, and the social security number showing my line of credit that I applied.
So how much is in that line of credit?
You say how much is in the line of credit?
Sure. If you got a line of credit, it's got to have a value. So how much is in it?
This is a procedural death blow. The judge is given every possible opportunity to demonstrate payment in a form recognized by law. He isn't being aggressive. He's being precise. Evidence of US dollars means something redeemable, transferable, and verifiable. When a defendant admits outright that no such payment exists, the case effectively ends. Everything before this moment was build-up. Courts don't punish beliefs, but they also don't honor imaginary systems. At this point, the only thing left is judgment. This case is a powerful reminder that confidence does not equal correctness, and belief does not override law. Judge Simpson followed due process, allowed full explanation, and made it crystal clear what courts require: evidence, clarity, and lawful payment. Sovereign citizen arguments continue to fail not because judges are biased, but because the legal system operates on objective reality, not internet theories. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.